Trump prosecutors now request a protective order from the judge. This is the classified documents case that's currently pending in Florida. Got a lot of questions about this case. We're currently scheduled for trial in like T-minus 3 weeks from now. Is that actually going to happen or not? We know that special counsel Jack Smith has asked to push this thing all the way back to December. We know that Donald Trump and his team want to push this thing off indefinitely. And so we don't really know where we stand yet. Judge Eileen Cannon is going to issue some orders on many of those things very shortly. But at the current time, Jack Smith is requesting a protective order. And we've gone through some other requests from Jack Smith and some other orders here, but they want limitations on what can be done in this case. And this is coming from them. And they're saying that Donald Trump and his team are not really being cooperative. They're not really communicating back. And so they're asking the judge to just make some decisions on how this case will proceed. And as we've covered some of these other protective orders and some of these other motions, we have seen that they have, in my opinion, tied Donald Trump's hands behind his back in many cases. In one of the other discovery orders, Donald Trump, as we recall, is not even allowed to take a copy of his notes home with him. He can take notes, let's say about the police report or about anything else that he sees in his case file, but he can't take those home. They all got to stay under lock and key with his attorney, and his attorneys have all these special rules and protocols that they've got to follow. And so if the defense attorneys and the defendant have to dance and do somersaults and cartwheels for the prosecutors in order to get the evidence, well, that's a little bit of a problem, isn't it? Let's see what Jack Smith and his people are asking for. This is the United States motion for protective order pursuant to CIPA, the Classified Information Procedures Act. And so this is Jack Smith, the prosecutors against Trump, coming in and asking the judge for protective order. You see, it is a 4-page filing in the Southern District of Florida. The case is against Donald Trump and Walt Nauta. Now, the prosecutors tell us, they say this case involves classified information. Trump was charged with willful detention of national defense information, and classified documents were collected as part of the investigation. And so CIPA applies to this rule because we're talking to this case because we're talking about classified documents. So they give us section 3. They say CIPA provides that the court shall issue an order upon the request of the United States. So they're telling the judge, you don't really have discretion on this. All right, the law says if it involves classified documents, if we ask for this, you shall issue an order that does the following: to protect against the disclosure of any classified information to any defendant in any criminal case. They say, in contrast, the discretionary authority of another section of the rule says that when classified information is involved, protective orders are to be issued whenever the government discloses classified information to a defendant in connection with the prosecution. So they're teasing out the rules for us. They're saying, Judge, look, some provisions of the rules say you have some discretionary authority to give us a protective order or not. We're not going to that discretionary provision. We're up here in a different section of the law. It says you shall issue an order. If we ask for it, you got to give it to us. On June 26, the court appointed an officer to attend to the classified review of this case. In July, the government sent to the lawyers for Trump the proposed protective order. July 12th. Government sends Trump a proposal. Say, we're requesting a protective order here. This is what we're going to give to the judge. What is your opinion on this? And this is ordinary in a criminal case. If somebody asks for a continuance, it's just standard practice to reach out to the other side and say, hey, what's your position on this? Do you object or not? You would put that in your filing. And we've seen that before. Jack Smith says, well, we want to push this case to a December trial date. Trump's people, here was their position. And in this case, they didn't object to that, but they just didn't agree to the December trial date. They wanted something further. So they say here, they sent him a letter on the 12th. On July 14th, so 2 days later, counsel for the defendants for Trump informed the government. They said, oh, thanks for the notice. We do intend to object to certain provisions of the order, but we're not going to tell you which ones. So prosecutors send this over to Trump on a Wednesday. Trump and his team responds on Friday. They didn't specify what they object to. The government writes, in an effort to narrow any disputes, the government asked to have a call on July 14th with counsel for Trump and Walt in order to see if it was possible to address their concerns. So they are sending emails back and forth. Can we just hop on a call? Defense counsel informed the government that they were not available that day. Sorry, we can't talk to you on the 14th on Friday. No, but we could find a time for the call the following week. Yeah, we have other things to do. We're not government employees, and we haven't been focusing only on this case 24/7 for the last 3 years or whatever, however long these people have been working on it. So no, we don't drop our actions for an immediate phone call request from Jay Brad. Government counsel responded that the government did not want to delay filing this motion because a protective order needed to be entered prior to the provision of classified discovery. We want this. Before we give you the documents, we're going to have this protective order. And we said, okay, well, the government's going to be available for a call over the weekend. and that it would be helpful for defense counsel to identify the provision that they found objectionable. But guess what? No. Trump's team, they're not going to work on the weekend, man. And remember, by the way, I'm sure they're working on the weekend, but they're not particularly interested in moving quickly on this case. So the defense is not experiencing the same urgency that the prosecutors are. They're like, hey, we'll talk to you on a Friday, a Saturday, or something. Like, I know, yeah. But it's the weekend, and my son has a soccer game, so I'll get back to you on Monday, bro. Sorry. Until they have, a judge who's encouraging them to hurry this along, there's no real reason to do that. So you can see the prosecutors are getting very frustrated here. Government counsel has not heard further from defense counsel since sending that email on July 14th. Okay, well, the day of this recording is a Monday. I mean, you sent the email on a Friday. It's Monday right now. But is now filing this motion to avoid further delay. Oh, so like they're angry. Hey, we tried to have a phone call with them and we sent them this notes and all. The government notes that since sending the proposed protective order to defense counsel, the government has made minor clarifying edits to a few provisions. So they say because the entry of the protective order is necessary in order to provide any classified discovery, the government requests the court require Trump to file an expedited schedule any objections to the proposed protective order. So like Trump needs to respond to this now and let us know exactly what he objects to, because we can't give him classified material until we get this protective order sorted out. And Trump's saying, well, that's true. We're not going to be able to get that classified material. And by the time we get it, it's going to be election season. And so then we might as well not have a trial right now. We might as well postpone that trial until after the election. So they're going to be dragging their feet through this entire thing. And so we'll see what the judge does about it. You can see Jay Bratt very agitated, and they ask that the court enter the following attached order. This is the actual protective order. So this is the government saying that we want this to govern all of the classified information as this case progresses. They say, all right, we're landing in front of this court in front of Judge Eileen Cannon. 18 U.S. Code applies under SEPA. They're writing this as though the judge has granted this. Now, the judge may take portions of this and reincorporate it back into their final order, but this is just kind of standard practice, is to give the court basically a draft order that the judge could just sign. Because sometimes the judge does that. The judge just takes the order. This is perfect. Motion to continuance, no objection from the defense. Okay, perfect. How far out we going? 30 days? Okay, great. Signed. Boom, done. They're encouraging the judge to just sign this right now. They say that the court finds that this case will involve information that's been classified and involves national security interests. The storage, handling, and control of this information will require special security precautions mandated by the law and require security clearances and need to know and all the different levels. And so the purpose of this order is to establish the procedures that must be followed by defense counsel, the parties, and all other individuals who receive access to classified info and documents in connection with this case. The presumption on this is that the government prosecutors are open and honest and full of integrity, and they would abide by these rules, and we don't need to give them an order. It's just the default. These are prosecutors. They swear an oath. They've got a badge. Whoa. And so we don't need to give them a protective order because they're already going to do things above board. Well, we know that they are constantly leaking inside information about this prosecution and about the character of the evidence to the media on a consistent basis. Happens all the time. I mean, portion of the segments that we do here are leaks from the media, from the Washington Post or the New York Times. I mean, we get a lot of the news from the leaks. Otherwise, where would it come from? If it's all really sealed, it would come through the public filings. But all of this always applies to the defense. And if the defense screws something up, they're going to blame the defense. Meanwhile, the prosecutor can leak like a sieve. The procedure set forth in this order shall apply to all pretrial, trial, post-trial matters, and they define things for us. The following definitions apply. What government means. All DOJ prosecutors, law enforcement, intelligence officials, and so on. The defense means Trump and all his people. Classified info means all of these things. Secret, top secret, formally restricted, sensitive compartmented information. Any document or information that is now or formerly in possession of a private party that's been classified. And so we go through the other definitions. What is the material that's classified? Everything. And so these are the definitions, right? It really encompasses everything. All classified documents or materials contained therein remain classified unless it bears a clear indication that it's been declassified. All access to this stuff shall conform to this order, and Trump may disclose classified information to the defense. The defendants may disclose classified info to the defense as necessary to prepare their defense. Well, that's nice. Any classified information provided to the defense by the government or the defendants are to be used solely by the defense for the purpose of preparing for the defense. It says Trump and the defense may not disclose or cause anything to be disclosed in connection with this case. This is the type of stuff that only applies to the defense. Reasonably believed or known to be classified information except as otherwise provided. The defense may not disclose classified information to the defendants unless that same information has been previously disclosed. And the defense may not confirm or deny to the defendants any assertion made by the defendants based on the knowledge that the defense may have had from the classified info. Okay, so I know this is painful to read and listen to, but we're having divisions of what the defense attorneys can talk about with the defendants. So Trump and Walt, right? Trump may know things, in other words, that other people do not know. And so if we're having disclosures back and forth, we're measuring the transfer of information. Who can talk about what? How can they talk about it? Any classified information the defense discusses with the defendants, okay, so like defense lawyers discussing with Trump in any way, shall be handled in accordance with this order. So if Trump's lawyers want to talk to Trump about this, they've got to follow these rules. The defense and the defendants shall not disclose any classified info to any person. Of course, the government does to the Washington Post. Information that is classified that also appears in the public domain is thereby not automatically declassified unless it's officially declassified by the executive branch. If classified information enters the public domain, the defense, Trump's people, are precluded from making private or public statements where the statements would reveal personal knowledge from non-public sources. They can't comment on the info. If there is any question about whether it's classified, they got to go through the classification officer. They say in accordance with these procedures, the defense shall seek info from the classified officer if they've got any questions about it. We also have a lot of very experienced prosecutors on this case that they've got all of the requisite security clearances like Jay Bratt, Julie Edelstein, David Harbach. They say that the defendants, Trump and his team, have a continuing contractual obligation to the government to not disclose any of this information, and they're subject to the court's authority, to their contempt power, if there is a violation. In other words, Trump is just not going to be emailed a police report. This is going to be a very complicated process. Now, part of the reason I wanted to share this with you is so we could see how complicated this is. And how are we going to get all this done before December? All classified information produced. The defense cannot copy, reproduce anything in any way, shape, or form. The defense shall discuss classified information only within the SCIF. So they have to go to a special room to look at this and cannot disclose any of this information otherwise. So very long, very technical order. And you can see they're asking Judge Eileen Cannon to sign off on this thing, just to say, all right, this is all valid. Judge, you don't have to change a word of this. Sign it. Trump's team needs to comply with it. And so my position on something like this as a defense attorney, although never working on a classified documents case like this, and quite frankly, I don't think anybody in this country ever has, because this is a case of first impression. It's a former president, current presidential candidate being prosecuted for being in possession of what I believe to be his own documents as the former head of the executive branch. But it is incredibly burdensome to the defense to have to do a bunch of stuff in order to even access the evidence. But it also is going to give them a bunch of holes and problems in the processing of this case where they can create delays. This was problematic. I didn't get access to that thing. I want access to that. They said I can't. Well, there's a conflict there. What do we look at? The Classified Information Procedures Act. Or what does that say? Well, we got to litigate that. And we want access to that, and they say we can't have it. Judge, I need you to hear this case. Regardless of what happens with that document, it takes time, and it's going to delay. So I think the takeaway is that this thing is going to be complicated and that it's going to cause delays. Now, this is what Jaime Raskin says when he was having a conversation with Jen Psaki.
Calling for an indefinite delay before he goes to trial. His lawyers are, I should say, in the classified documents case. And Special Counsel Jack Smith's prosecutors argued strongly against any delay. Is there any valid argument for a delay?
I don't think that there should be any delay in existing prosecution. Otherwise, any criminal defendant in the country would declare for president or Senate or House or mayor and say, you can't prosecute me anymore. You got to wait till next year or the year.
Why didn't I think of that, man? I could have won every single case. Just have everybody run for office.
After, think of it this way. If somebody is running for office and then is implicated in a murder or a rape or an armed robbery,
run for president.
Would we say, no, we're going to hold that until after the election.
Yeah, just
if
run.
in the normal course of events it would take place before. He should be treated exactly the way anybody else would be treated in the same situation. There have been hundreds of prosecutions of people on the basis of crimes that took place on January 6th. Why should he be special?
Jen doesn't even respond. I think even Jen's like, what the hell kind of answer is that? Well, it's about a fair trial. It's about, can you get a fair and impartial jury if it's Donald Trump on there? And I think that Raskin is just equating Donald Trump to every other common criminal out there, which is something that they want to do, but it's not something that is realistic. I know they live in a fantasy land, but the reality is, in America, we have something called the presumption of innocence and due process and equal protection of the law. And so the defendant deserves a fair trial. And that means that you got to have a fair jury. And the question that we have, that even the Justice Department has, is can you have that, or do prosecutions impact elections? Obviously they do. Even the DOJ won't bring charges within a certain period of time lest it impact the outcome of the election.